This video will introduce you to the UCC, the Uniform Commercial Code, which is Article 2, the sale of goods. It will discuss when the UCC applies to a particular fact pattern and contract, and how formation differs under the UCC from formation under the common law. We will also discuss firm offers under the UCC. So the first thing you need to ask yourself is, when does Article 2 apply? And the answer is anytime you're dealing with a transaction in goods. Goods are defined in the code as anything that is movable at the time of identification to the contract for sale. So Article 2 applies anytime the contract deals with a transaction in goods. It does not require that there be merchants involved in the contract. Sometimes we'll see that particular rules under the UCC will apply differently if we have merchants, but for UCC Article 2 to apply, you don't have to have merchants. It could be two individuals, two law students entering into a contract with each other for the sale of goods, and the UCC would apply to it. So one question is, what contracts are not covered under the UCC? And the primary ones to keep in mind are contracts dealing with real estate or the provision of services. Those are two very common contracts that don't deal with the UCC. Others are leases and the sale or licensing of intellectual property, patents, trademarks, etc. Also keep in mind that even if the UCC applies, you will still be applying common law to some aspects of the contract. So the UCC will provide for specific statutes, and if one of these statutes applies, then you will apply it. Otherwise, common law will govern that issue. For example, the UCC does not define an offer. So even if the contract you're talking about falls under the UCC, you will be dealing with common law rules in terms of how an offer is formed, etc. And common law, of course, just refers to the law that is formed by court opinions and that is restated in the Restatement Second of Contracts. Another rule to keep in mind is if it is a mixed contract for goods and services. So the contract itself might involve both the sale of goods and the provision of services. To figure out whether the UCC applies, you apply the predominant purpose test. You ask yourself, is the predominant purpose of the contract the sale of goods, or is it the provision of services? Some factors that are helpful include looking at the language of the contract and its purpose, its primary purpose, the nature of the business of the supplier. Is this particular supplier one that commonly provides services, or that is more a provider of goods? And also the intrinsic worth of the materials. Do they outweigh what the intrinsic worth is of the actual supplies? So figure out, is the predominant purpose the sale of goods? If so, the UCC will apply. If it's the provision of services, then you'll apply common law. So we've already looked at formation of contracts under the common law. We've noted that bilateral contracts are ordinarily formed by an offer plus acceptance. Offers are freely revocable until they are accepted, unless you have an option contract. Under the UCC, formation is a little bit less strict, and the UCC states that a contract for the sale of goods may be made in any manner sufficient to show agreement, including conduct by both parties which recognize the existence of such a contract. So even if you can't pinpoint an exact offer and an exact acceptance, we still have a contract if the parties are acting like they have a contract and they're recognizing the existence of a contract. Similarly, an agreement sufficient to constitute a contract may be found even though the moment of its making is undetermined, even though we can't pinpoint the exact moment at which an offer was accepted. If the parties' conduct and actions indicate that there's a contract, then we will find there is an agreement. And then even though one or more terms are left open, a contract does not fail for indefiniteness if the parties have intended to make a contract and there's a reasonably certain basis for giving an appropriate remedy. So under the common law, courts are stricter about requiring that all of the material terms be agreed upon for there to be a contract. Under the UCC, we look primarily at their intent. Have they intended to make a contract? If so, then we will find that they made a contract, and we will look for a reasonably certain basis for giving an appropriate remedy. We'll talk further about specific terms that are required to be included in the UCC. We'll see that sometimes even if the parties haven't noted a price, we can still find a contract to be formed if there's a reasonably certain basis for coming up with that price, what the parties intended. The firm offer under UCC allows an offer to be irrevocable even though there hasn't been consideration given for it. And this is different from the common law because, as we said, in the common law, you can have an option contract requiring that an offer be held open, but there needs to be some kind of consideration, even if it is just nominal. The courts will require some payment of consideration. Under the UCC, if you have these 5 factors, then you might still have an option even without consideration. So 1 is there must be an offer. 2 is it must be by a merchant. And remember, we said that the UCC will apply whether or not there are merchants, but some provisions apply differently if there are merchants. This is one of those provisions. The firm offer can only be found when it is a merchant who's the one who is making the offer. Okay, the offer or the purchaser, usually. To buy or sell goods in a signed writing, which will, by its terms, gives assurance it will be held open. So a merchant makes an offer in writing and states that it will be held open for a specific amount of time. That will be found valid and not revocable for lack of consideration during the time stated, or if no time is stated, then it's irrevocable for a reasonable amount of time. But in no event may such period of irrevocability exceed 3 months. So what the UCC says is if you make your offer and it's a merchant and it's in a signed writing that says it's going to be held open, the offer will be held open for a certain amount of time, then that is a binding option contract and is not revocable for lack of consideration, but only up to 3 months. Finally, 2205 states that any such term of assurance on a firm supplied by the offeree must be separately signed by the offeror. So, in other words, if the form that includes this assurance that the offer will be kept open is a form that was provided by the offeree, then we have some reason to think that the offeror might not know about it, might not have been informed of it specifically. And so we're going to require that the offeror sign that term of assurance. Make sure that the offeror is aware of what he is agreeing to. Okay, so these 5 requirements. It's an offer, and of course we know that the common law is going to help us to define an offer, by a merchant, which I'll talk about in just a second, to buy or sell goods in a signed writing and says it's going to be held open for a certain amount of time. If that's the case under the UCC, then it's not revocable simply because there's no consideration. So it's a different scenario than under the common law, where we're going to require at least nominal consideration and that it actually be paid. Now, who is a merchant? Under the UCC, a merchant is defined as a person who deals in goods of the kind involved in that particular contract, or who otherwise holds himself out as having such knowledge or skill. So we're going to look at the type of goods that are being bought or sold in this particular contract, and a merchant is a person who deals in those kinds of goods. So a lawyer or a bank president buying fishing tackle for his own use is not a merchant. Just because he might be one of these people might be considered a professional or might be considered a merchant for other purposes, they would not be considered a merchant in this particular circumstance. But the seller of the fishing tackle, if it is a company that does this on a regular basis, would be considered a merchant. And of course, as we just saw under the firm offer rule 2205, it doesn't matter whether the offeree is a merchant. This particular provision will apply as long as the offer is made by the merchant.